Hey there, it is me, attorney Hattie Harp, and today I want to talk about Michigan deeds. Okay, I got a call this morning about a child who had his parent and his uncle who owned a property together. His parent unfortunately died at some point, and then now the uncle has passed away, and his cousins, so his uncle's kids, are telling him that they own the property based on what's written in the deed. And they're thinking, how can this be possible? Because their parent and their uncle owned it together. Well, it is possible, but it ultimately depends on the type of deed that they had. In Michigan, there are a few types of different deeds which can affect how property is then owned after the death of someone. So I'm going to run down quickly the different types, and we'll go from there. How does that sound? So the first type could be just a fee simple. If, for example, I bought a house, it was deeded to me in my individual name, I own 100% of it, it's just me. When you start to add on people onto a house, that's when the different variations can affect what's going on. The first type that is typically um, transferred is through tenants in common. So someone buys a house with, say, their brother or their friend, they'll typically take ownership as tenants in common. Okay. So if they each own 50% of it, or that was their intent, okay, and one of them passes away, the one that passed away doesn't lose their 50%. It just goes to their heirs, whether that's by will or by intestate. Uh, that's another story there. But tenants in common will preserve your ownership after you die, and that your ownership will go to whoever you had designated in a testamentary instrument. Now, the flip side of that is there's something called joint tenant with right of survivorship. So if those same two people were to buy a house or buy a piece of property as joint tenants with right of survivorship, then upon the first one passing, their interest will then go to the other one, and the one who basically outlives the first one is going to be able to take ownership of the entirety of the property, and at that point they can do whatever they want with it. All right, so that's a very big difference. There's a difference between taking a property as a tenant in common and as a joint tenant with right of survivorship. The outcomes can vary widely, and for big commercial properties, or for any property that matter, it could be a sizable chunk of your estate if you're not careful, if you're not paying attention. So, in the example that I gave with the client who called in this morning, they probably had a joint tenant with right of survivorship deed, which is the reason why their cousins are telling him, no, 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 cuzzo, this property belongs to us because it was joint tenancy. Your parent passed away well before our parent, and since our parent had complete control at the time of his passing, it's going to go to us. Unfortunate, but that's why knowing how your deeds are titled is critical. Now, we talked about tenants in common. We talked about joint tenant with right of survivorship. There is a third and critical type of deed here in the state of Michigan, and it only applies to those who are married. Okay, if you have a spouse and you have a marriage, then you're able to take title in what's called tenancy by the entireties, or tenancy in the entireties. Okay, it's similar to joint tenancy in that upon your passing, your spouse will get your property. For most people, that's great. They want their spouse to get their property upon their passing rather than tenants in common. Then you may have to deal with probate court. So, tenancy by the entirety avoids that tenancy in common problem. And just gotta grab this guy right here. Uh, he can get annoying sometimes. And so tenancy by entirety will avoid that problem. But in addition to that, it gives you the benefit of creditor protection. So creditors can not seize or attach a lien to a property when it's held in tenancy by entireties, if it's a debt of just one spouse. So if one of your spouses has a debt, let's say they've got a lawsuit filed against them, let's say, yeah, typically it would be a lawsuit. Maybe they're a doctor, maybe they get sued for malpractice, or maybe they have a lot of businesses. For whatever reason, they've got a debt or a loan, some default against them. If it's just against one of the spouses, then that property that's held in tenant by the entirety is protected from those creditors. Now, if it's the debt of both spouses, then it wouldn't be protected. But for the typical situation, it does provide a heightened level of creditor protection for spouses. So typically, if you're a spouse, you're going to want to hold your property in tenancy by entireties. Now, this all assumes you're not trying to hold your property in trust, which is another option and another video for another day. But tenancy by the entireties is a possibility here in Michigan, especially if you're concerned about your spouse incurring a debt. The last thing you want is one spouse incurring a debt, and then the family had to think about how they're going to make sure their kids have a place to live. So that's a really nice benefit here in Michigan, tenancy by the entireties. So those are the main types of deeds that can exist for the typical situation, uh, that should apply to pretty much everybody. You can hold it in a fee simple if it's just yourself. It can be tenants in common, where it's basically fractured ownership interests, 50-50. It could be 25-75. You could have 10 people owning 10% each. Each of them continues to hold their interest even after they pass when you have a tenants in common. Joint tenant with right of survivorship, that's a scenario where upon your passing or upon someone else's passing, their interest gets absorbed by the other people who are still alive. And then finally, tenancy by the entireties is only for spouses that are legally married. The benefit there is it provides creditor protection against debts of a single spouse. So, hope you learned something. If you want to chat about anything we talked about today, just visit estateplanchat.com. Again, estateplanchat.com. We can jump on a phone call. It's free, it's easy, it's convenient. You can schedule a time right now. So, visit that if you want. Estateplanchat.com. Thank you again. I appreciate you. And until next time, uh, be good.